See, nigga first was used back in the deep south, falling out between the dome of the white man's mouth. It means that we will never grow. You know the word, dummy. Upper niggas in the community think it's crummy, but I don't. Neither does the youth, cause we embrace adversity. It goes right with the race, and being that we use it as a term of endearment, niggas start to bug to the dome is where the fear went. Now the little shorty say it all of the time, and a whole bunch of niggas stole the word and they rhyme.
You sign up for Facebook, you sign up for terms of service. Are you familiar with that?
Yes.
Okay. It says, the terms govern your use of Facebook and the products, features, apps, services, technologies, software we offer, Facebook's products or products, except where we expressly state that separate terms and not these apply. I'm a lawyer, I have no idea what that means.
Facebook and New England attorney Norm Pattis have both disrespected a court order that dealt with my mom's passing from this earth. And they are both legally and morally aberrant for their actions. They put me in a place where white men of privilege could disrespect a court order and deny me the opportunity to legally broadcast about our mother on the world's largest open forum in history. And it was all steeped in Facebook denying their own stated terms of service. Watch this.
If I may interrupt, Joe?
Yes.
I'd like to briefly object to that because I believe the court has jurisdiction at this point. I believe the court had, as my briefings indicated, the court had jurisdiction ab initio from the time that I attempted notice to the defendant. And the court had jurisdiction to grant the TRO initially, and certainly after I provided actual service to the registered agent after attempting to find a registered agent in this state. At that point, the court certainly had jurisdiction to issue the contempt orders as well. And so I believe this court has full jurisdiction at this point to determine contempt.
Great day. You're with KingCast and howtosuefacebook.blogspot.com. Now watch for the court hearing on 11 December before Judge Rule in the King County Superior Court. It should be live on Facebook, and I'll also be making a YouTube video as well. And I'll be updating my Roku TV show, Corruption Meets Camera, soon too. I already have a story about Facebook up there on Roku, so check it out. Roku, Corruption Meets Camera. You can also see the videos replicated on my YouTube channel, and they're on the blog, How to Sue Facebook, blogspot.com. Okay, so this is the first in a series of YouTube videos designed to explain how and why I am suing Facebook for terms of service violations when they keep putting black activists like me in Facebook jail. Now keep in mind, it's not just black folks, but anyone whom this hegemonic corporate juggernaut feels like discriminating against, they do it. But former diversity wonk Mark Lucky and others have expressly noted that Facebook discriminates against blacks, and my request for judicial notice number 2 goes into that. Now, we all need to band together, in my opinion, and start suing Facebook for terms of service violations on a contractual and promissory estoppel level. Terms of service is an adhesion contract, and it's enforceable in a court of law, folks. Catch a clue. I'm not telling you how to do it, just telling you it can be done. Now, the underlying reasons they banned me 3 times this year included my complaining about this corporate white Wells Fargo foreclosure attorney attacking me, and the hearing officer doing nothing about it other than throwing me out when I asked him why he didn't admonish that lawyer. Mark Rattan is his name, and we're suing them in Wisconsin on that right now. The lawyer I was working for covering this video, progressive white female attorney, protects homeowners in foreclosure. They're screwing her, so I was there to document it, all right? Google Wendy, Allison, Nora, plus KingCast. I'm not going to deal too much in the absolute merits of the suspension. We'll get to that later. But right now we're going to be addressing the TRO and everything. But basically they banned me because they said that bracketing the races on a biased sheriff's report and claiming that race was the reason the report was biased was hate speech. But that's not hate speech. I helped write the Ohio statutes on hate speech when I was a law clerk in the early 90s for Lee Fisher and Terry Gilbert, progressive civil rights attorneys. Okay? Lee Fisher was the Attorney General of the state of Ohio. It's not hate speech. All right? Not even under their rationale. We'll get to that later. Now, they also, I appealed that, okay? They came back and they said that my post after that, complaining that I felt like someone treated me as a nigger, the sheriff ignored a white guy dropping 5 F-bombs in my face for no reason. And I can't say more about that because I was there to investigate a bad dog kennel, and that's settled. But in any event, that's not hate speech. You know, they have a Harvard lawyer whose law school outranks mine by about 40 spots, okay, when I was there. She's the policy director. She says that protected groups can call themselves, you know, names. It's like they're embracing the language and using it in a sense of empowerment. And their own terms of service say that. We're going to get into all that later, okay, in the next videos. But anyway, so they put me in Facebook jail, and my mom died. And I made every attempt to notify Facebook of my concerns. I needed to get in there and talk about my mom. So the court, you know, I made every effort I could to reach them. You'll see that. The lawyers were complete jerks. Cooley is their law firm, by and large, and they offered no assistance and were quite rude to me. Watch this.
Client, I'm not sure who your registered agent is or Facebook's registered agent is for service of process, but I'll be finding them shortly, and my people will then be filing the lawsuit upon them. That will be that, but for this purpose...
We're not going to accept this.
Okay, I'm going to leave it here. I'm leaving now. I'm here, by the way, I'm here on a valid court order. It's not trespass. It might be licensee or invitee, but it sure as hell is not trespass, and I'm leaving, and it's staying right there. Goodbye.
Now anyway, boy, they continued to ignore things after I got my official service on them on the 13th of November. I filed a lawsuit, I think on the 8th, whatever. On the 13th, I got service on them, okay? And to a registered agent in California. And I've addressed all of their assertions in their motions to get rid of this. Number one, I don't need to have direct official notice of the lawsuit or the request for a TRO in order for the court to obtain jurisdiction to issue a TRO, okay? Two, the court definitely maintained jurisdiction after I served their registered agent on the 13th of November for the contempt show cause hearing. 3, I don't need to post a bond, and I have a case that says even if the court should have ordered a bond for the TRO but did not, the defendant has to show prejudice. Facebook cannot meet that test. Oh, they're prejudiced, all right, but they can't show it within the legal context. Anyway, I didn't file an affidavit about my efforts to obtain service in the state of Washington before using the California registered agent. Well, too bad in my motion for show cause or contempt, I noted in paragraph 2, I think it was, I swear as on oath, before I detailed my efforts to, notify them. So that doesn't work. And then I filed a formal affidavit as well. So now keep in mind, Facebook knew through my appeals process that I was suing them and seeking a TRO from the get, okay? They are abusive, and they're built to stay that way. Now, I sent them a demand letter that they ignored without a counteroffer. They're going to regret that.
Camera here.
That's correct, Your Honor.
Perfectly all right. I am not allowing you, however, to include court staff in the photograph or the video. So, to the extent it is including my clerk here, I'm directing you to take her out of the video. All right? And that's fine. Will that do?
Yes.
Very good. Thank you, sir. All right. And if you are planning, this is for your own information. If you are planning, I understand that there's a hearing upcoming. Is that correct? Is it on the 11th?
11th.
Tuesday, the 11th, sir. For Judge Rule, I can't speak for him directly, but if you plan to or wish to film any portion of that hearing, you would need to contact his bailiff in advance and get his permission and authority to do that, okay?
Of course.
All right, very good, that's fine.
Have notified as well.
And that's perfectly all right. The reason I mentioned that, and I just give this for your information again, I saw the notice of media coverage document that you filed. That by itself, I don't believe is sufficient because he won't have advance notice of it until he picks it up and gets it on.
Oh, yeah, I left the working copy with him.
Okay.
Emailed him, so.
All right, perfect, that's fine. Very good, so I have received, remember this case, so here's my concern this afternoon. And that concern really relates to the upcoming hearing on the 11th. And that is a motion to dismiss or dissolve the temporary restraining order. I have not reviewed that motion. It appears that one of the bases that, I'm going from the response that I did receive from counsel, is that there are procedural issues with proper service, allegations, that kind of thing. Are those part and parcel of the motion to dismiss as well?
They are a key part of the motion to dissolve the TRO.
Yes, okay.
Jurisdictional issues as well as statutory and rule-based issues.
Correct.
And so I've identified those for purposes of today's hearing, but I'm not asking you to rule on any of this.
All right, and I understand that. That would be for Judge Rule to rule on. So, what I'm going to do today is, because of the nature of the objections that are procedural in nature, if it turns out on the 11th that Judge Rule finds that the order should not have been entered or was entered improperly, then there could be no basis to find Facebook in contempt because it would be rendered moot. What I am going to do, and counsel, I'm going to ask you to do this, and Mr. King, ask you to wait until you can take a look at the order that is entered. I am going to continue this hearing today to the hearing before Judge Rule on the 11th for him either to make a determination regarding, once he has ruled on the motion to dissolve or terminate, either to make a determination regarding contempt or, based on his ruling, to refer it back to me.
If I may, for the record, Judge?
Yes.
I'd like to briefly object to that because I believe the court has jurisdiction at this point. I believe the court had, as my briefings indicated, the court had jurisdiction ab initio from the time that I attempted notice to the defendant. The court had jurisdiction to grant the TRO initially, and certainly after I provided actual service to the registered agent, after attempting to find a registered agent in this state, at that point, the court certainly had jurisdiction to issue the contempt orders as well. And so I believe this court has full jurisdiction at this point to determine contempt.
And were it not that there was a motion that is currently pending regarding dissolution or essentially vacating the TRO, we would hear an argument about that. I would go ahead and hear this matter. I think in the interests of judicial economy, frankly, if nothing else, and I think it's proper procedure, I'm going to let Judge Rule make a determination on the 11th, and either he can deal with the contempt issue at that point. If he chooses not to do that, then he can send it back to me, and I will make a ruling as well. So I'm going to ask you, counsel, to tweak your order, please, and show that order once it's tweaked to Mr. King, and then I will sign it.
May I ask one question before we do that?
Yes.
Just looking at the local rules and local rule 40B and 40.1B2, if it appears that the motion, the contempt sanction motion, should be made to Judge Rule, and that there could be a show cause order that gets filed ex parte, but if there's an assigned judge, it should go to the assigned judge. So I'm just wondering if it should be not deferred to him to kick back to you, but sent to him to be decided.
Well, and so what I'm saying is I am doing just that. What I'm leaving the door open for him is if he chooses, and he has the discretion to do that, if he says, well, I'm not going to rule on the contempt motion, that in his discretion, in my discretion, I'm sending it back to the commissioner, that's fine. Otherwise, the matter is set before him to make a ruling. Okay?
Very good.
Thank
Very
you.
well, none of my objection. I appreciate it. Thank you, Your
All
Honor.
right, thank you, sir. And let me give you back each the working papers. So if you need to, you can provide them to Judge Rule. And I think there's Mr. King. I'm going to put your papers together. Give you back your response, thank you.
And did this include the supplemental authority as well that I just filed today?
It includes everything that I received,
Okay.
as far as I know. If I don't have it.
Yeah, that's here. It's here.
Cool, very good.
Thank you. We'll be back with it.
All right.